Breaking news, a federal judge just struck down the Texas Republican redistricting map. Did redistricting just blow up in the faces of Republicans nationwide? And what about the fate of Prop 50 here in California? Coming up, we'll tell you all about the legal challenges in California and in Texas and everywhere in between, and why we're still hopeful Prop 50 may be shelved. I'm Carl DeMaio, chairman of Reform California and a California state representative, and this is getting very messy, particularly for Republicans. It could quite possibly result in Republicans losing seats because of the redistricting schemes that have been entertained in the past 6 months nationwide. Now, look, let me just put my cards on the table before I get into the two lawsuits that we're following right now and the potential outside chance that Prop 50 might be overturned here in California. I have said from the get-go, politicians should not be manipulating the lines of their own districts, full stop. We should not have politicians manipulating lines, choosing the voters. We should have the independent citizen redistricting process in every single state in the union. Californians got it right back in 2010 by taking the power away from politicians and putting it in the hands of communities to draw lines that represent their ties and maximize their voice. Prop 50 here in California eviscerates that and eliminates the whole notion of any fairness in elections. And so when I look at what's going on in Texas, I'm frustrated because it's the wrong way to do redistricting. So let me sort out the two court cases that we're following, because there's one court case in Texas and then there's one court case here in California. The Texas court case was decided literally this week by a 3-judge panel overturning the Texas map. Texas appeals, the federal court of appeals ruled that the Republican favored map is racially gerrymandered, that it basically puts minority communities at a disadvantage. That's what the Democrats were arguing. The judges said, well, we're going to agree with the Democrats. The Republicans were saying, no, we did not draw it based upon any intent of going after and undermining race. We never said anything about race. We said everything about politics. We wanted to get more seats for Republicans. That's what they argued in court. And that's exactly what they did. They didn't say, oh, we're drawing a map and boy, we're so happy that we have these majority districts. They didn't say that at all. Never claimed that whatsoever. It was all about partisanship. And the Supreme Court has said that you can certainly draw maps based on partisanship. And there's nothing in the state of Texas's constitution nor in its state law prohibiting drawing maps based on partisanship. Nothing at all. This is important because it does apply to the Prop 50 legal challenge that we're backing here in California. So the judges said, nope, you can't use this new map. It infringes on minority rights. And so Republicans have announced they're going to appeal this to the U.S. Supreme Court. Now, mind you, there's already another court case pending at the Supreme Court regarding Louisiana and redistricting. And Louisiana is trying to overturn some of the requirements under the Federal Voting Rights Act that said, well, you should really draw districts that are majority minority to give these people an opportunity to have their seat. And what Louisiana is claiming is that this violates the 14th Amendment, equal protection, due process. You cannot use skin color, immutable characteristic, just like you can't use religion or gender, to make decisions in government. And so the Supreme Court is weighing the Louisiana case, and in the hearings that they held in October, it seemed pretty strongly that the Supreme Court majority was leaning towards at least modifying, if not overturning, the concept of drawing districts based on race. So you have Louisiana looking like the Supreme Court doesn't want to use race. You have this Texas court saying, oh, you have to draw a map to benefit people's skin color. Now let's talk about California. In California, there is a court case. We're suing to overturn Prop 50. And what we're alleging in this court case is that the Democrats drew a map based on race. So we're basically connecting the argument to the Louisiana case. And we're saying, we don't think it's right that you draw districts based on people's skin color. And in fact, by packing in all the African Americans or all the Latinos or all the Asians into one district, you dilute their voice in other districts. Who says that putting them all in one district and giving them just one seat is fair? Are you possibly diluting them? The whole notion is, if you're using anything that is prohibited in the 14th Amendment, gender, skin color, religion, if you're using any of those immutable characteristics in a government decision, you're on thin ice, if not in violation of due process and equal protection. And so in California, we're saying Newsom and the Democrats openly said, not only are we doing this to get Democrat seats, that's not in doubt, and that is a common thread between Texas and California, but Newsom and the Democrats said, and we are maximizing minority seats. We've added another minority seat in Los Angeles. They literally were crowing about it, proud about it. We used skin color as our basis for drawing districts, is what they basically said. The lawsuit also points out that under the Voting Rights Act, there is a very complicated and data-driven analysis. So if the Voting Rights Act is thrown out, then the map, Prop 50, is on shaky ground. It could be overturned. But even if it's not thrown out by the Supreme Court, the requirement under VRA, Voting Rights Act, is that you're supposed to do a very detailed, data-driven analysis and make various findings about racial minority districts. None of that occurred in Prop 50. They drew maps in the back room. They said that they were doing it for partisanship. They did no VRA data sets or analysis, no tests, which are done in other states. So the due diligence that went into the decision was not there. There's no evidentiary record that they did the analysis assuming VRA, Voting Rights Act, is still on the books. So they're damned if they do, damned if they don't, under the allegations in our Prop 50 case. So the Prop 50 case, the Texas case was decided this week. Now it's on appeal. The California case will be heard on December 3rd. So it's just around the corner. And the reason why that's so important is that candidate filing begins in mid-December. So the judges have to make a decision on this ASAP. They either have to say, okay, we're going to use the Prop 50 maps, or they have to say, there's enough here that's a problem. We're going to tell you, don't use the Prop 50 maps, use the existing maps, which is basically what these federal judges said in Texas. Don't use the new maps, stick with your old maps, take it to the Supreme Court. So that's what we're hoping for, is that the judges in California, the federal judges, will say, don't use Prop 50 for 2026. Get this before the Supreme Court. Let them sort all this nonsense out. If they don't say that, boy, Republicans are screwed. Because it's quite possible that the Texas map will remain nullified and the Democrats will get what they want. One other point that you should ruminate on and share with your Democrat friends and your independent, friends. Remember what brought Prop 50 about? Texas, Trump. If they're cheating, we should cheat. If they're rigging the election, we need to rig the election. Fight fire with fire is what Gavin Newsom said. He said it was only temporary. If Texas backs down, we won't do it. Oh, but they conveniently and quietly took the Texas trigger out of Prop 50. Oh, I know. For those of you thinking, oh, well, since Texas isn't doing it, that means that we get fair elections, fair lines, Prop 50 is done. No! The Democrats stole it fair and square is what they say. They're not going to back down. So much for morality and principle and ethics and, oh, we won't do it if they won't do it. Bullshit. Gavin Newsom's been a liar and a thief the whole time. He has no credibility and no integrity. Prop 50 does not go away even if Texas's map gets overturned. And you need to rub that in the nose of your Democrat and independent friends and family and just say, you have no leg to stand on anymore. You said the ends justified the means. We have to rig the elections because they're doing it in Texas. Now Texas isn't doing it, and you're still rigging the election. So spare me your moral indignation about Trump and saving democracy. You are the greatest threat to democracy. You have committed the heinous sin. It has always been about might makes right. Now, let me tell you one other wrinkle here. Oh, this is a shocker no one's talking about. Let's say that Republicans get their way in Texas and they get their map. And let's say that here in California, we prevail with the Prop 50 lawsuit and the judges say, yeah, this was done based on race and you can't do that anymore. Or if we still are able to do race, you didn't do enough analysis. So we're setting aside these maps. You have to do it all over again. Does that mean that the Citizens Commission gets to redraw the map? No. Does it mean that Newsom and the politicians get to redraw the map? No, not under our current constitution, but hey, the state constitution be damned. They've already violated the state constitution multiple times to get Prop 50 on the ballot and to cram it through. Might makes right in Gavin Newsom's world. So who would draw the map if we win our Prop 50 lawsuit? Well, let's take a look at the only controlling language for how do you draw a map if the existing map gets thrown out. It is found in Article 21 of the California State Constitution. And you see, do you understand why you love us here at Reform California? We do the deep, geeky dive so that you're the smart one at the dinner party. Basically, what it says is if the map gets overturned, then the California Supreme Court shall be the only body to develop a map. It says here, if the commission does not approve a final map, or if the voters disapprove a map, the Secretary of State shall immediately petition the California Supreme Court for an order directing the appointment of a special master or special masters to adjust the boundary lines of that map in accordance with redistricting criteria and the requirements set forth in subdivisions D, E, and F. Upon its approval of the master's plan, the court has to approve the master's plan, shall certify the map to the Secretary of State, and the map shall be made final. So let's take a look at what the criteria would be for D, E, and F. So the California Supreme Court would have to, if a map is struck down, they would be the ones to appoint a special master or masters to draw a map. What's section D, E, and F? Well, D says they shall establish districts based upon equal population. So that's a no-brainer. Second criteria, and it says in the following order of priority. So first is equal population. They can still rig an election with equal population. We've just seen that. Number two is the Voting Rights Act. So minority-based districts. If the Supreme Court of the United States throws that out, number two is eviscerated. It's taken out. Or if it's modified, they have to now comply with the new modifications in the Supreme Court ruling. So if this gets taken out, that priority is gone. So we go first with equal population, then geographically contiguous. Okay, well, so you could argue that instead of compact, it just has to connect. Okay. Oh, but hold on this. The next criteria is the geography, integrity of a city and county, local neighborhood, local community of interest shall be respected. So that then becomes the next big criteria. So it has to be equal population. They have to connect geography-wise. And now, instead of VRA, now it has to be compact, sensible geography decisions. Now, if all of this is followed, you may not discriminate against a political party. That's Section E. The Democrats' Prop 50 map clearly discriminated against the Republicans. And so Section E becomes a game changer because we would then be able to sue before the Supreme Court. Now, who's in charge of the map? The Supreme Court, the state Supreme Court. Now, I guess we could probably come up with a case at the federal level, but the federal level tends not to get involved with state decisions. They'd say, well, look, let the California Supreme Court wrestle with whether or not this was done right. Oh, who are you suing? Oh, the California Supreme Court. It's going to be very hard to take this to the federal courts. They'd be loath to intervene. They've done it in the past, but it would be quite extraordinary. I'm talking about a complete mess. That if at best we win this lawsuit with Prop 50, at best, we're looking at maybe trailing for 2 years the use of the Prop 50 map or some other perverted version of a map. We may end up at worst with a worse map than Prop 50 because Prop 50, followed the VRA. And as a result, you got some Republican seats in the mix. What's to say the California Supreme Court isn't going to just simply say, we're all Democrats. We serve the master. We serve Newsom and our Democrat friends. We want to be invited to the cocktail parties. They've shown before that they are strictly partisan. They're not judges. They're political operatives. They're activists. And I believe that there's a risk that the special master process may result in a worse map for Prop 50 than the one we even have now. And that's hard to imagine. Look, at Reform California, we're going to be fighting to restore the citizens' redistricting process, break the Democrat supermajority in Sacramento, and of course, do something good for our elections. Enact the California Voter ID Initiative. If you haven't signed the initiative yet, please go on the website, voteridinitiative.com. Download, print, sign, and mail back the petition as soon as you can. We need 1 million signatures, and we can't do it without you. Also, go to reformcalifornia.org. Check out our stories up there, chip in a contribution, put fuel in our tank. And if you haven't signed up to be part of our growing movement statewide, please do that at the bottom of the website. First name, last name, email, phone, and zip code, and you'll be tethered into our growing movement to take back California from the insanity of the far left. Until next time, I'm Carl DeMaio, Chairman of Reform California and a California State Representative. Thanks for watching, and I hope you enjoyed this episode. But before you click away, please subscribe to this channel and click that notification button so you get updated when we post new episodes. Plus, like this video and share it with your friends so that we can help spread our message across the state.